My name's Gabe Slater. I represent Andy Park, and I'd like to ask you a few questions on his behalf. And I know this must be difficult for you, so if you need to take a moment at any point, it's totally all right, okay? Now, Jesse, I'd like to start by asking you about a drawing you made for a school project. You were asked to draw you and your best friend. Do you remember that?
Yeah, it was a while ago, but I think I remember it.
And would you recognize a copy of this drawing if I showed it to you today?
Yeah.
Your Honor, let the record reflect them approaching the witness with what has already been entered into evidence as Plaintiff's 3. And Jesse, this is a copy of that drawing, right?
Looks like it, yeah.
And you titled this drawing, Me and My Gun.
Yes.
And Jesse, I just want to highlight one portion of this for the jury. In the bottom middle panel, you wrote, "This is me and my gun."
Objection, Your Honor, to substantially more prejudicial and probative.
Okay, argument?
Your Honor, there's no probative value to going over the picture drawn by Jesse Duran, because if there was any probative value in this picture, the opposing counsel would have to prove extremely similar circumstances, which of course they can't, because this is the picture Jesse drew when she was 8 years old, completely different situation from what actually happened on August 18th, 2010.
Yeah, but counsel, wouldn't the child's propensity for violence or gun use go to certain elements of their case? If she has a certain propensity and they have to prove that the parents, should have known about it, then wouldn't this go to that?
No, Your Honor, once again, if there is any probative value in something, it has to be under extremely similar circumstances, and that part is just not met by going over the picture that was drawn, because it is, after all, a picture drawn 3 years prior to the accident.
Yes, Your Honor. Your Honor, first, for anything to be held out under these grounds must be substantially more prejudicial than probative. And the probative value in this goes in demonstrating what Lee Duran's knowledge was of Jesse's past behavior. Now, pursuant to the 2011 case of Sokol v. Kitchener, in pursuing that verdict, we can help demonstrate Hayden Duran's knowledge of Jesse's past bad acts and actually demonstrate those past bad acts for the jury. We can also see this in the 2013 case of Totten v. MAF. Essentially, for the jury to be able to weigh how Hayden Duran responded to Jesse's actions, we need to know what these actions are, and thus going through the elements of this drawing has a highly probative value to the jury.
Response?
Yes, Your Honor. Again, if they were to have any probative value, they have to be extremely similar circumstances. Because this is a picture drawn by Jesse, there would be no probative value to this, which would make this substantially more prejudicial because it only has prejudicial value.
Counsel, asking her about what she meant by something that she drew, how would that really go to, what her mother knew or should have known?
Your Honor, if I can be clear, I didn't ask this for this question, and I just wanted to highlight a portion of the jury. Now again, pursuant to Totten v. MAF, part of the way that we can establish what Hayden Duran knew, and in turn the jury can weigh if Hayden Duran's response was reasonable or not, is if they know the information Hayden Duran actually had to work with. And thus, breaking down for the jury the information Hayden Duran saw is highly probative in today's case. It goes directly into our burden of looking at Hayden Duran's negligence.
Your Honor, may I respond?
One more time, yes.
Totten versus MAF is only going towards Midland's Rule of Evidence 404, which is character evidence, which has nothing to do with substantially more prejudicial than probative. As we've already explained, there is no probative value because this is not an extremely similar circumstance.
Well, I'm going to overrule the objection for now, but it is well taken, and you can feel free to renew it when we see where this line of questioning is going.
Yes,
but
sir.
For now, with the question that he's asked so far, I think it's admissible.
Yes, Your Honor.
And Jesse, I just want to highlight one portion of this for the jury. In the bottom middle panel, you wrote, "This is me and my gun scaring all the bad kids away," right?
That's what it says.
And Jesse, you brought me and my gun home, isn't that right? you showed me and my gun to your mom.
I think so.
And when your mom saw me and my gun, she didn't take away your video games, did she?
Not that I can remember.
Your mom didn't ground you, did she?
I don't think so.
Now, after seeing me and my gun, your mom put the drawing on the fridge, right?
Objection, Your Honor, to substantially more prejudicial than probative.
Yeah, I think it goes to the, the notice that she had, goes to her knowledge. I'm gonna allow it.
Yes, Your Honor.
Jesse, just to be clear, after you showed me and my gun to your mom, she put the drawing on the fridge.
Yeah, she put almost all my sport on the fridge. It was kind of embarrassing, but
Thank you, Jesse. I'd now like to ask you about a time where you got into trouble at school. Do you remember getting into a fight in gym class?
yeah, I had an argument with some of the kids.
And you're aware that a report was written up about that fight by the school?
I think so, yeah.
You recognize this report if I showed it to you in court today?
I think I could.
Your Honor, let the record reflect I'm approaching opposing counsel in the witnessing turn. Who has been marked as plaintiff 5 for identification?
Okay.
No objection to the authenticity, Your Honor.
Would Your Honor look at courtesy copy?
Yes.
Jesse, this is that notification of student discipline, right?
Yeah.
And this looks to be a fair and accurate copy of that notification?
Yes.
Your Honor, we offer plaintiff 5 into evidence.
Any objections?
Yes, Your Honor, on 3 grounds: to hearsay, to character evidence, and to substantially more prejudicial than probative.
Okay, let's, I'm not gonna exclude it on the 3rd ground. Let's hear your argument on your first 2 grounds.
Opposing counsel is trying to use the statements written in the document as taking those for the truth of the matter asserted. Those would be hearsay because they're out of court, written by the head of the school, which is why those would be hearsay. As far as character evidence, they're going to try and assert that because Jesse Duran had behaved a certain way in the past, that Jesse Duran would behave a certain way in this case.
May I respond, Your Honor?
You may. Let's hear your response on the hearsay argument.
Certainly, Your Honor. This notification isn't actually being submitted for the truth of the matter asserted. Now, opposing counsel just suggested that we're using this to show that Jesse's actions actually did take place, that are described in this notification. That's not what we're doing. All we're using this notification to do is focus on Hayden Duran's knowledge of this notification. And if you look to the bottom, Your Honor, there's actually Hayden Duran's signature. We're not offering this for the truth of Jesse's actions, but rather so the jury can weigh Hayden's response, just like the previous ruling about the cartoon.
May I respond, Your Honor?
Response?
In order to weigh in on Hayden Duran's reaction to this disciplinary note, you have to take the statements in that disciplinary note for the truth of the matter asserted. Otherwise, there's no point, which is why they are using it to prove the truth of the matter asserted, and so that way they can try and make a point on Hayden Duran's reactions.
Your Honor, we're not planning on asking any questions about the actual actions Jesse took. All we're going to ask about is about if Jesse showed this document to Hayden Duran and Hayden Duran's response to it. That's not hearsay. It's not being used for the truth of the matter asserted.
Okay, your response to the character evidence argument?
Certainly, Your Honor. If I can just direct you to the case law we just looked at, Cotton v. MAS of 2013, it specifically says that evidence can't be held out under Midland's Rule of Evidence 404, which is improper character evidence in this case, because such evidence goes towards Hayden Duran's knowledge and Hayden Duran's response to that.
Counsel, are you able to show that this witness had any knowledge of whether her mother received notice of it or not.
Your Honor, if we like, we can lay that foundation before we enter into evidence.
If, I'm gonna allow you to try to, lay that foundation, and then we can revisit the objection,
Yes, Your
Certainly,
Honor.
okay?
Now, Jesse, your mother saw this notification of student discipline, isn't that right?
I think so. I mean, she signed it at the bottom.
And your mother talked to you about this notification of student discipline, right?
A little, I think.
Your Honor, we now offer Plaintiff 5 into evidence.
Okay, arguments as to whether a proper foundation has been
Well-
laid?
Yes, Your Honor. Well, proper foundation has been laid to fulfill the Taunton v. MAF portion of character evidence. This would still be hearsay because, again, the only way that this notification has any relevance or any point is if they're using those statements for the truth of the matter asserted.
May I be heard, Your Honor?
Not yet. Okay, counsel, I'm gonna overrule the objection and admit, this exhibit, but, only to the extent that it shows notice. And
Certainly.
so there will be a limiting instruction that the truthfulness or untruthfulness of the statements in here and the events described, it's not admissible for that purpose.
Yes, Your Honor. So Plaintiff 5 has been entered into evidence, though, with a limiting
For that limited purpose,
Yes.
Yes, Your Honor.
Now, Jesse, I'd like to direct you to the bottom of this notification. There's a statement of acknowledgement, right?
Yes.
It says, I have read the notification above and agree to implement discipline at home so that my child does not repeat this behavior at school. Did I read that right?
That's what it says.
And right below that, Jesse, below that statement of acknowledgement is the signature of your mother. Isn't that right?
Yes.
And Jesse, your mother talked to you about this statement later, right?
Yeah.
But your mother didn't take away your video games, did she?
I don't think so.
Your mother didn't ground you, did she?
Well, no, I was suspended from school, so I have to stay home all week anyway.
But to be clear, Jesse, after seeing this notification and signing it, your mother didn't punish you in any way, right?
Not really. I just thought that my suspension was my punishment.
So that's a yes to my question. Your mother didn't punish you in any way.
Yes, no.
Thank you. And Your Honor, at this point, I constructively published Plaintiff 5 to the jury.
Okay, with the limiting instruction.
Yes, Your Honor, of course. Thank you, Jesse. Now, I'd now like to ask you a little bit about the events of August 17th and August 18th. Now, on the night of August 17th, you told your mom about the Parks gun, right?
Yeah.
You told your mother that you thought it would be fun to play with the Parks gun, right?
Something like that, I think.
So that's a yes to my question. You told your mother on August 17th that you thought it would be fun to play with the Parks gun.
I think so, yeah. I wanted to hold it and just see what a real gun was like. It was kind of going through the military phase at that point.
And Jesse, the next morning, your mother let you go to the parks, right?
Yeah, I had plans with Sydney.
And Jesse, you remember later that day when the police came to the park home, right?
Yeah.
And you're aware that you made a statement to the police?
I don't remember writing it, but they told me I did.
So you are aware that this statement exists, right?
Yeah.
And you'd recognize a copy of this statement if I showed it to you in court today.
Yeah.
Let the record reflect I'm approaching the witness who does argue and enters in evidence as plaintiff 1. This is a copy of that statement, Jesse,
Yes.
and it looks to be a fair and accurate copy, right?
Yes.
And Jesse, like you said, your memory regarding this statement is a little bit hazy, right?
Yeah, after everything that happened, I just don't really remember a lot.
But Jesse, you know that one line in this statement is completely true, right?
Oh, yeah.
So Jesse, just to be clear, the statement you wrote, Hayden Duran told me real guns are just like the ones in video games, is completely true.
Well, yeah, she taught me that people get killed in video games by guns, so people can get hurt with guns in real life too.
So that's a yes to my question. Your statement, Hayden Duran told me real guns are just like the ones in video games, is true.
Yeah.
Thank you. No further questions, John. And I'd like to just read.
Yes, you can,
Yeah, the clerk tries to find some. Thank you.
anything further?
Yes, Your Honor.